Good morning and welcome everybody to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you everyone so much for being here. Thank you for carving out some time on your Sunday to join us. You're not going to regret it. First of all, I'd like to point out how prompt I am, how absolutely on time I am this morning. I'm patting myself on the back for that. Thank you everybody. Cheryl, I see you in the chat, and Genny Dickey and Susan and Afton and Tiff Knox and JC Broadway, Susan D. Thank you so much for joining us. The Curvial, I think that's what the name was. Thank you for stopping by and saying hi. My name is Joshua Ritter. I was a prosecutor with the LA District Attorney's Office for 10 years, more actually. And then I left and went into private practice as a criminal defense attorney. This is Courtroom Confidential, where we try our best to present to you both sides of the courtroom, and we hope that we do that. And this is, of course, Sunday Fun Day, where a bunch of you have left us messages throughout the week, and we've tried to answer as many of them as we can. I will say this: we were not able to get to all of them. Don't let that discourage you. A lot of the time, I just try to pick one that kind of answers the question everybody's concerned with. But if you didn't get your question answered this week, please, please, please call again. We love to hear from you. All right. Hey, Gisela, lurking while working and then taking you all on a jog with me. She always making me feel like I need to get my fitness game in check. So good for you, Gisela. Enjoy the jog. We will be chatting about you, I'm sure, while we do this stream this morning. If you haven't already, guys, take a moment, please like that, hit that like button, subscribe to this channel if you haven't already, share this with somebody that you think might enjoy it. And remember to stay to the end, because we do have some announcements for you, some stuff I think that you're going to enjoy. Let's get to these questions, though, because you guys really came through once again. I will say at least 2 cases that you asked questions about I'd never heard of. And one of them is wild. One of them has stuck with me. So we're going to get into all of that stuff. I think you're going to really enjoy it. Annalie Finch, thank you so much for kicking us off with the super chat. Looking forward to another Sunday Fun Day. So am I. All right. Should we jump right into this? Crazy Mom RN, thank you so much for gifting a membership. Farm Girl, thank you for gifting a membership. Blessed by Hesed, for becoming a YouTube member. Appreciate that. I think you're going to enjoy it. And Johnny Knoxville says, that's not Seafoam. No debate on that. You are correct, sir. This is not Seafoam. This is one of our new shirts, and I will show you why later. This is not just one of our old school black shirts that we used to have, that we still have. All right. Let's jump into these, shall we? Going to our first caller. Who's going to kick us off this morning?
Hey, Josh, it's Annie Kemp calling from St. Babs, Santa Barbara, California. And I have a question about Wendy's derivative use immunity. Since it's based upon her testimony being truthful, wouldn't it be voided by any lies she might tell? And can't that be proven with her testimony, since we know that some of it's untruthful? Thanks very much, and love to everyone. Bye.
Annie from St. Babs, Santa Barbara, California. Thank you so much for kicking us off, and with a great question. A question that, by the way, a lot of people are asking. The Donna Adelson trial started last week, obviously. They've already gotten into the first couple of days of witnesses. Starting on Monday is the expectation that this lady right here will be testifying. That's Wendi Adelson. And people want to know about her derivative use immunity. What does that mean? What are the consequences? Is it to her benefit? Is it to the prosecution's benefit? Spoiler alert, it's for the prosecution's benefit. But Annie from Santa Barbara has an interesting question about this, because part of an immunity agreement, and that's what it is. The best way to think about it is as a contract between the prosecution and the defense, or the defendant, or the witness. Actually, in this case, it's just the witness, is as a contract. Part of that contract is she has to testify truthfully. If she does not testify truthfully, null and void. Now, does that mean that she wants to make sure she testifies truthfully, it better be, because if they null and void that whole thing, they can go back to court and they can say, we want to use what she said against her, which is the specific provisions of the use agreement, use immunity agreement. So she has a very big reason to not lie. But does that mean she has to tell all the truth? It does. Does that mean she's going to try to get cute about it? Perhaps. Does that mean that she'll kind of shade things in a certain way? Perhaps. Does that mean that she might not tell the whole truth? Perhaps. It's a dangerous game she's playing. But Annie says, well, what if they can prove it? What if they can prove she's lying on the stand? That's a very different thing. Now, in practice, well, let me say this. According to the terms of the agreement, if she lies and they can prove it, null and void. They can go after her for everything, including stuff that she said on the stand. But if it's close call, if it's up to interpretation, if there's room for argument and wiggle room there, not so much. I believe the way it would have to work is they'd have to go in front of a judge, because her attorneys would lose their minds if they just all of a sudden said, that's a lie. Now we're going after you for everything you just said. It will probably be very hotly litigated. But your question is a great question, Annie. Absolutely. Absolutely. If she's not truthful, that they can tear that whole immunity agreement apart. So thank you so much. Great question. A lot of people have been wondering about this. And like I said, stay tuned. Tune into Courtroom Confidential live trials tomorrow. We expect her to testify. All right. Let's get to our next question here. Not working? Oh, I was so proud of myself too.
Hi, my name is Dr. Vonda Kay, and I'm calling from Kingsport, Tennessee. Josh, in the Mick Patel case out of Georgia, we saw how exculpatory video evidence existed, but wasn't quickly brought to light, leaving him jailed and vilified for weeks. From your perspective as a former prosecutor, what safeguards should be in place to make sure evidence that could clear someone is reviewed and disclosed quickly, so people aren't left as collateral damage in the system? And as a follow-up, how do you reconcile the prosecutor's duty to protect the public with the duty to seek justice, especially in cases like Mick Patel's, where the video clearly contradicted the charges, but the case still dragged on for months? Thanks so much, and have a wonderful day.
It wouldn't be a Sunday fun day if I didn't have some technical difficulty somewhere, right? I mean, hopefully that will be the only one. We'll get it done early. But thank you so much, Dr. Vonda Kay from Kingsport, Tennessee. Let's put you on the map. What a great question. And it's about a case that I feel like I had seen this come up in my Twitter feed, but I did not look into it. And it's a really fascinating and disturbing case. It's something that should bother all of us. And Dr. Vonda Kay asked a question about it. What can be done? What are the safeguards? If you guys don't know about this case, let me give you a little bit of the background. This gentleman right here, who Dr. Vonda Kay refers to as Nick Patel, but his real name is Mahendra Patel. Mahendra goes to a Walmart, I believe it is, and he's shopping around the Walmart. This is in Ackworth, Georgia, back in March of this year. He asked this woman who's in one of those motorized carts and has a toddler with her for help finding the Tylenol. He's an older gentleman looking around for the Tylenol, asks her for help. She agrees to help him. Somehow in the midst of that, her 2-year-old son, it appears as though she may have clipped like the end of an aisle there, if you can see it. And this is screen captures from videotape. And in doing that, the 2-year-old either starts to fall or looks like he's unstable. And Patel puts his hand out to grab the young man to make sure that he doesn't fall. Well, mom reacts to that, and he immediately kind of takes a step back and puts his hands down. He doesn't want them to think that he was doing anything bizarre. He was trying to be helpful. Here's where things get really problematic. If that's the incident, by the way, okay? He then goes about and finishes his shopping. He then goes and checks out at the counter. He has a 20-second conversation with one of the employees there before he leaves. He is casually going about his day. Why is that a problem? Because mom, say what you will about mom. Did she overreact? Is she being overly protective? I don't know. But mom reports him. Police are involved. She tells him that it was an attempt to kidnap her son, that he tried to grab her kid. She stopped him. They go out and arrest this poor man for kidnapping, for attempted kidnapping. They say that he attempted to kidnap this young man and then ran from the store. Now, there's a difference between what is reported to officers and then later on what they are able to gather in evidence. And that's always the case, right? Unless a crime takes place in front of the officers, they're usually going off of witnesses and victims, what they're telling them. So they're writing up reports. They write up a report. It sounds awful. It sounds like an attempted kidnapping. It sounds like he attempted to flee. They go out and make an arrest. Here's where the breakdown really begins to happen. He's in jail. He's held in custody on attempted kidnapping charges. I imagine the bail on that was enormous. They take their sweet time getting the surveillance. Now, you could say, is that a problem with the investigation? Is that a problem with just the how long it takes to get surveillance? Sometimes I know this. It takes a while to get this surveillance video. But you have to imagine, were they asking for other witnesses? Were they speaking to staff there? Did anybody say anything that could corroborate this mother's story? I imagine no. Yet they're still holding this man in. Then the videotape comes out. And the videotape obviously shows the way that he explained it. That's the other thing, is I imagine they interviewed this man and he told them, no, the poor young man was falling and I tried to help him. And then I went around purchasing my things and I didn't think anything was wrong. End of the day, we could talk about this forever, but it is one of those things where whether there were bad intentions on the part of the mother or whether she was simply mistaken and is being protective of her child, a crime was reported that simply did not take place. This is not one of those situations, in my view, where it's arguable. You know, we say videotape captures everything. It doesn't. Sometimes something can happen and you can interpret how it is on that videotape. But this videotape so clearly impeaches what she is saying took place that this man should have been released immediately. He's not. He spends 45 days in jail. Then he's been accused. Then his face is all over the news. Now he's got reputational harm. There's a famous quote about, and I'm forgetting now who it was a politician who was accused of a crime and then vindicated. And when he was being interviewed by the press afterwards, he says, yeah, everything's great. Now, where do I go to get my reputation back? What department do I report to get my reputation back? And that's what poor Mahendra Patel is going through. So Dr. Von de K's question, though, is what safeguards should be put in place to avoid this? And was this simply a failure of the system? Having been a prosecutor, I got to say that I try my best to give these prosecutors the benefit of the doubt. Doesn't mean they always deserve it. But in a case like this, I imagine this is how this went down. A report is taken by a police officer, a patrol officer, responding to the scene, responding to a 911 call. He takes a report. The report sounds awful. That lands on a prosecutor's desk. Where the breakdown likely took place is that prosecutor should have done some follow-up first. Now, did they feel like this man was somebody they needed to really be concerned with? Well, they could have interviewed him. They could have ran a background check on him. If it came up that he had prior arrests for similar types of things, I could understand them moving so quickly. But you would think, and this happens all the time, that they could have said, let's take a breath. Let's go out and get some corroborating evidence. Did you interview other witnesses? Do they corroborate what the complaining witness is saying? Did you get videotape? This is a Walmart. There's videotape all over the place. You're telling me this wasn't caught on video? Let's go do that and get that before we bring these types of serious charges and put this person in jail. That wasn't done. Somehow something fell apart. The answer to your question, Dr. Von de Kay, is there are safeguards in place, but safeguards are only as good as those who use them, right? If you're not using them, if you're not employing the best practices, then it's all going to fall apart like this. This was a miscarriage of justice. Thank God they dismissed the charges. Thank God he's out now. But again, where does he report to get his reputation back? Where does he report to get those 45 days of jail back? Sad thing, good result at the end of the day. Sad case, unfortunate case. And I think, yeah, if you're going to place the blame on anyone, place the blame on the prosecution for not, like I said, taking a beat before they did anything about it. All right, let's keep it rolling here. Lindsay Brillhart says, any updates from Wagner in Ohio from Friday? Did we have updates? I'm not sure. Oh, yes, we do. Our live reporting. This just in. The hearing was rescheduled to a later date, so it didn't happen. So there you go, Lindsay Brillhart. Thank you for asking the question. And you can always get to-the-minute reporting here on Courtroom Confidential. So thank you for that. And thank you, Best Nancy, for gifting the membership. Appreciate you. Arizona Gal says, hi, Josh and CC family. My 9 a.m. counseling client was a no-show, so now I get to log in for Sunday Fun Day Live. Sending love from Tucson. So glad to have you here. Good morning, and thank you for joining us. All right, let's keep it rolling. Let's make sure Josh is going to do this correctly. No more mistakes, Mr. Ritter. Not my fault. This is a technical difficulty. I'm pressing all the right buttons.
Hey, Josh. Hey, everybody in the chat over at Courtroom Confidential. So happy to gather with you guys today. I hope everybody's having a fabulous Sunday. And my name is Bluebird 711, aka Lisa Shelton, from the great state of Kentucky, specifically Waddy, Kentucky. My question this morning is about Wendi Adelson and the immunity deal that she has. I know that it is a use and derivative use immunity and that they can't use what she says in trial against her specifically. But I'm a little bit confused as to the part that they can also not use evidence that is potentially found as a result of any of her testimony against her in the future. If you could explain that a little bit better for me. And also, I'm curious about, I know that she's highly against having or speaking on behalf of the defense. Does the court ever allow an immunity deal for the defense side as well?
Great questions. Like I said, everybody wants to know about this immunity deal with Wendi, and I think it's a great opportunity for us to explore this. And by the way, this is a concept that even prosecutors and defense attorneys still have a tough time wrapping their heads around. So Lisa from Waddy, Kentucky, thank you so much for asking the question. Let's answer the second part of your question first. Can the court grant immunity for the defense as well? Here's the thing. The court isn't granting immunity. Immunity, like I said, the best way to think about it is a contract between the prosecution and the witness. And when you think about it that way, you start to realize who has the power to prosecute someone. The prosecution. The judge doesn't have the power to prosecute someone. This is the separation between two branches of government, between the executive branch with the prosecution and the judicial branch with the judge. judicial branch cannot say, go charge this person with a crime. That's what the prosecutors do. Now, because they are the ones who can decide whether or not to charge someone with a crime, they can also agree to not charge someone for a crime if they enter into some sort of immunity deal with them. You give us something, you give us testimony, we will give you something, in that we will not prosecute you for the things that you say on the stand. So when you think about it that way, how could the defense ever get involved in that whole game? The defense doesn't decide whether or not to prosecute someone. They have no power to decide whether or not to prosecute someone. You imagine if the defense could, they'd be handing out immunity deals all over the place. So it's only the prosecution who can enter into this deal, and the defense cannot do that. And the judge's role is just making sure that the terms of that are all enforced, but not actually granting it. That's the second part of your question. The other part of your question is this idea of what is the derivative part of a derivative use immunity agreement mean? So, first of all, use, meaning we cannot use your testimony against you. You get on the stand, Wendi gets on the stand, and she says, let's say, this is a hypothetical, let's say she has a moment of clarity and she says, yes, this was all planned and I was in on the planning. Now, they cannot use the words she said, I was in on the planning, against her. They can use all of the evidence they may have pointing to her against her, but those words that came out of her mouth, they cannot be used against her. That's the use part of it. They also can't use things derived from her testimony. For instance, if she says, well, have you guys talked to Jim McIntyre? Jim McIntyre is the person you need to talk to. And she says that on the stand. Well, the reason I know this was all planned out is Jim McIntyre was helpful in this entire process. I'm just making up a name here, obviously. And police go out and they go, we never heard of this guy. And they go interview Jim McIntyre. And Jim McIntyre tells them a bunch of helpful information they had never heard before, including stuff that may implicate Wendi. They cannot use that because that was derived from evidence that Wendi gave while she was on the stand. That's the derivative part of it. So the direct use of her statements or things derived from her statements. It's like the fruit of the poisonous tree kind of a concept. What did they learn from her statements that they would not have learned otherwise? Now, as in the fruit of the poisonous tree, there's also this concept of independent discovery or inevitable discovery. Would they have found Jim McIntyre? Would they have interviewed him otherwise had she not told them about him? Those become interesting questions. But if they're learning something for the first time from her, and that sets off a chain of events that leads to an investigation that never would have been available to them had she not testified, none of that can be used against her. So that's the use part and the derivative part of her immunity. But again, this immunity, you cannot think about it as a transactional immunity, meaning she will never be prosecuted for a crime. She can absolutely be prosecuted for a crime for anything that they know independent of her words on the stand or things derived therefrom. So she's not getting any kind of get out of jail card here. All she's getting is, in fact, she's not getting anything. She's being compelled to testify because they are taking away her Fifth Amendment privilege. She would, believe me, if she could, and we'll get into this a little bit more later on in another question, if she could, she would refuse to testify. She doesn't want to testify. She doesn't want this use immunity. She wants nowhere near the stand. She never wants to open her mouth again about this entire case. They are compelling her to testify. The only protection she has and refusal that she has is her Fifth Amendment rights, and they're taking that away by granting her this use immunity. Excellent question, Lisa from Waddy, Kentucky. Jim McIntyre will never go away. Yeah, if you know, you know. All right, guys. Let's keep it moving here. Let's keep it rolling.
Hi, Josh. My name is Carrie. I am from Cape May in New Jersey, and my YouTube handle is The Quiet Fringe. My question revolves around a case that had happened back in June. 16-year-old Trey Wright. He was fatally shot near Johnsonville, South Carolina, in what authorities have called a deadly teenage love triangle. 9 teens, including his girlfriend, were arrested, and 19-year-old Devin Scott Raper, yes, that's his name, was charged with murder. At his bond hearing, which you can see online, Raper claimed in front of the judge that his phone held evidence to clear him, but the judge denied his bond and told him to speak, of course, with his court representation. This case raises a couple of questions. I'll condense it into one. How does the justice system assign responsibility and determine sentencing when multiple teens are involved in a violent crime, in this case, a murder? Thank you so much for everything that you do. You have the best community, and I'm just so happy to be a part of it.
Oh, Carrie, we're happy to have you a part of it. Carrie, AKA the Quiet Fringe from Cape May, New Jersey. Let's put you on the map there. Oh, there's Cape May. Wow. Never been to New Jersey. Maybe I should take a trip. This is a really sad case out of Myrtle Beach, North Carolina, about a young man named Trey Dean Wright, who was, there he is. I thought this is the photo they got of him with a snake around his neck, but he's just a young guy. I mean, I think he was 17 years old at the time that he was murdered. And he was shot by another young man who I believe was only 18 at the time, named Devin Raper. Look at them. They're children. This kills me, this kind of stuff. Well, it's this whole love triangle over another young girl who looks like an absolute child named Gianna Kistenmacher. All these kids right here that they're showing, all of them are either juveniles or just barely 18 years old. They have all been arrested now and charged with murder because there was some sort of love triangle, and I use that term loosely, between Gianna and Trey Dean Wright, the victim, and she lures her own boyfriend to a location where Devin Raper is waiting with a loaded firearm, and a conflict breaks out and he ends up shooting him to death, multiple gunshot wounds. These other young folks, Corrine and Hunter and Sydney, they're all in on it. They're all in on the idea of luring him there to this kind of secluded area. They all know that Raper's got a gun. They all know that the gun's loaded. They all know that he's made threats against Trey Dean Wright. It's just an horrifically awful story. Yes, 9 total, but I believe only 5 of them charged with murder. Others of them are charged with kind of accessory before the fact types of things. They videotape this. There's videotape evidence. It's just a horrible, horrible case that is also, what are these children doing? Where are they getting these ideas? Why are they involved in this kind of stuff? What's going through their minds? They've taken one man's life and ruined their own lives over something so completely stupid. But Carrie's question is, how are they being charged like this? What do you do in a situation where you've got all these people? How are they, what is the level of culpability for every person involved? Well, the sheriff in this area gave a statement, and he used a very interesting term that you don't hear all that often, but it is the concept of, he said, in this case, the hand of one is the hand of all. What does he mean by that? Well, what he's doing is using some kind of poetic language to describe what I would just call accomplice liability. Oh, did I say North Carolina? South Carolina, pardon me. Accomplice liability. And the idea of the natural and probable consequences doctrine. Here's what that says. If you are involved in a crime, let's call it a armed liquor store robbery. And you guys know that you're going to go rob a liquor store. I'm the driver. Jim McIntyre is going to go inside with a gun, and we've got somebody else with us who's going to be the lookout. Okay. Everybody's got different levels of involvement in the whole thing. I'm just sitting in the car. I'm just sitting in the car with the engine running. It's Jim who's going inside with the gun. And it's somebody else who, Tiffany, is the lookout. But because we all know that Jim is armed, and we know that's a highly volatile situation, and we know that the natural and probable consequences of committing an armed robbery is that that gun may go off and somebody may lose their life, we are all going to be held responsible equally for that murder, because there's what's called the target offense, which is the armed robbery, but natural and probable consequences says that you can also be held responsible for the non-target offense, which was the natural and probable results of that crime being the murder. Here's what's interesting and what is really powerful about this doctrine is that as long as there is reasonable foreseeability in that I know that Jim is armed with a gun, Tiffany knows that Jim is armed with a gun, we know he's going to go in there and commit a robbery, giving us reasonable foreseeability of the highly, highly dangerous situation, then no specific intent is required by anyone. No specific intent is for the murder is required by me, by Tiffany, even by Jim. Jim could have made that decision at the last second to shoot the store clerk, okay? This doctrine says, listen, we're not going to require that the prosecution prove the specific intent of all these young folks. But when they knew that they lured a young Trey Dean Martin to a location where Dean Raper was armed with a gun and had already said that he wanted a conflict with him and already talked about threatening this young man's life, they're all on notice for that non-target offense of murder, and they don't have to prove specific intent to have committed the murder as long as it was reasonably foreseeable to everyone involved. Hope that makes sense. It is a difficult concept. It is a kind of nuanced and complex concept, but at the end of the day, you realize why it's in place. Why are we going to put that extra burden on the prosecution to prove what was the specific intent of everyone involved? Because they're all going to go, I didn't know he was going to do it. I know he had the gun, but I didn't think he would use it. No, sorry, not the way that you get off for this one. And again, these kids who look like they should still be in elementary school are probably going away to prison for a very, very long time. So sad case. Thank you so much, Carrie from Cape May, New Jersey, for asking the question. And thank you so much, Kathy Mama Bear, for the gift of memberships. Appreciate that. Perry for the super sticker. Beautiful looking cat there. I always say this wrong. Julia Dunner says, I'm 53 and Josh and Courtroom Confidential makes me want to go back to law school. Thank you so much. That's so sweet of you. Tracy from Florida says, I have shoes older than these kids. That's a good point. I think I do too. I need new shoes, speaking of which. All right, let's keep it rolling here.
Hi, this is Granny Detective from Calgary, Alberta, Canada, and I enjoy your show, love watching it. My question is, if BK is going to be allowed to pursue his PhD, and why would that be? Why waste the money on something like that? And is it truly an accurate representation of what he should do to receive a PhD? I hope that makes sense. It just seems to me that it's not something that he should be allowed. It should be life without privilege, and he should have no privileges, especially getting to complete his education. And I just wonder why they allow people like that to pursue these types of things. Thank you very much.
Granny Detective. First of all, I love that name, Granny Detective from Calgary, Alberta, Canada. Thank you so much. Let's put you on the map. You got no arguments from me. I get it. I understand it. Why should he be allowed to have the privilege? I like the way you put that. The privilege of continuing to pursue his education while he's in prison. Why are we putting taxpayer money into this? Why are we, it is a privilege to call yourself a PhD recipient. And why should he have that? There is, of course, the young folks that we're talking about with Kaylee and Maddie and Xana and Ethan, who all tragically lost their life. I have a hard time looking at this picture every single time when I think about just how on the cusp of just such beautiful, bright futures they were, and to have them stolen from them by this absolute monster. And a monster who, according to Granny Detective, still has the opportunity to pursue a PhD. I don't know if that's happening, by the way. But I do know that they have many programs for people who are inmates to pursue higher education. Here, I guess, is a way to think about it. Oh, wow. Thank you so much, June, for the gift of 20 Courtroom Confidential memberships. I love it. We need that little icon you were working on, Kaylin, the fireworks or something like that for the 20 memberships. So everybody enjoy. I think you'll enjoy the membership program that we have here. We work very, very hard at it. And by we, I mean Kaylin and Tiffany, and I just show up. Here's the way I think is probably best to think about it, Granny Detective, though, is they're in there. He's in there for the rest of his life. And we gotta, I think having inmates, lifers, giving them distractions is probably better than not. Giving them something to do that is least arguably constructive is probably better than not. Having them sit around and do nothing all day long probably is going to lead to more trouble for the security guard, the guards, than it is for anybody else. They want these guys occupied. They want them passive. They don't want them sitting around sharpening up shivs when they got nothing better to do but to get into further trouble. At least let's give them some, what is it? The idle hands are the devil's playground, or whatever the phrase is. I think that's kind of the thinking behind it, is give them something to do. And if that's something constructive, fantastic. I'll be honest with you. I think back when we had them breaking rocks was probably a good thing to have them do. But nowadays, having them, there are jobs that they can have in prison, by the way. We know of many facilities that do, license plates are still an actual thing. But, if that includes getting their education, learning something, bettering themselves, I get it. I get what you're saying, Granny Detective, but I also think let's keep them, the devil's workshop. There you go. Let's keep them occupied rather than not. But thank you so much, Granny Detective from Calgary, Alberta, Canada. All right, let's keep it rolling here.
Hi, Josh. This is Mike. My handle name is Grendel on YouTube. And I'm from Newtown Square, PA. My question is about two cases. First case is Aaron Spencer versus the state of Arkansas. Do you believe that Aaron's case falls under the Arkansas state law of self-defense? And if you do, why do you think that the prosecution is pressing so hard with what he's being charged with, as well as why do you think the judge was so quick to order a full gag order on everything and everyone involved? My second case is Stephan Stern's case. Could the judge have denied the no contest plea for Madeline's murder? And if so, why didn't he? What would denying his plea of no contest for Madeline's murder look like or cause? Thanks again. Love Sunday Fun Day. Bye.
Mike from Newtown Square, Pennsylvania. Let's put you on the Mac. Mike, one of my dudes, one of my Courtroom Confidential dudes showing up. I appreciate it. Good to hear from you, my friend. Great questions. I'm going to answer your second question first. This is about the Stephan Stearns case, horrible, horrific case, the systematic abuse of Maddie Soto that culminated in her eventual murder. There she is, beautiful young girl that lived a nightmare of a life before her life was actually taken from her by this completely evil monster of a man. And when he took his plea for her murder, interestingly, not for the SA stuff, but for the murder, he entered a no contest plea. And a lot of people had questions about that. Why was he allowed to do that? What are the consequences of that? Well, the consequences of that are essentially nil. They're essentially nothing. The judge will say, when you take a no contest plea, that I am going to treat your no contest plea as a guilty plea for all effective purposes. The only benefit, I guess you could say, that I've ever heard in connection to a no contest plea is on the civil side of things. That if a person is also being sued for that crime, that they can, from a civil perspective, say, well, they didn't actually plead guilty, they pled no contest. And even what effect that has in a civil context, I'm not even all that sure. I don't even think it matters a hill of beans in the civil context, but it's something that exists. The reason it exists, quite frankly, is when you have people who our courts have allowed for it with people who they felt like they legitimately want to pursue a plea agreement because they realize that the consequences of going to trial are dire, but they don't want to have to admit guilt for something that they feel that they didn't do. And so we allow for this kind of gray area, no contest plea. But in situations like this, I agree with you, Mike. I think the prosecution said, no dice. Sorry, dude. I want to hear the words guilty come out of your mouth. And they could have compelled him to do that. I think the prosecution here was like, whatever you want. Just you're going away to prison for the rest of your life. And that's all that we care about. But just so that you feel better, Mike, it has no effect. No one cares. The only effect it has is there wasn't that moment of the word guilty coming out of his mouth. But is that worth something? I don't know. Perhaps from a pure perspective, maybe. Your other question, Mike, is about Aaron Spencer. And this is a case that is really, I think, one we're going to be following closely because a lot of people have a problem with this case. There he is, glorious beard and two glorious turkeys along with him. And this case, just to give you the real cliffest of Cliff Notes versions, is about, it's out of Arkansas. Aaron Spencer's young daughter, 14 years old, I believe she was essayed by a older gentleman. That man had been arrested and that man was pending charges in the middle of the night. And I'm blanking on his name. I should have put this down, but he doesn't matter in this whole story. Well, he does, but he doesn't. In the middle of the night, after this man has already been arrested and charged, Aaron hears his dog barking. I'm talking about like 1 o'clock in the morning. Hears his dog barking, goes into his daughter's room. She's not there. He calls 911, and he is, I can't even imagine. I mean, I'm getting chills thinking about it. He is losing his mind. Michael Fossler is the name of the other man. Losing his mind. Where's his daughter? Calls police. And of course he thinks Fossler's got her. So he gets in his truck and goes out looking for this guy, spots the vehicle, gets him to pull over. His daughter is in fact in the vehicle with him with a loaded handgun, tells the guy to let her go. Now, depending on what the actual facts are, but the reports are that as the daughter tries to get out of the vehicle, that Fossler tries to stop her. At one point, it's believed that maybe Fossler lunged at Spencer. End of the story, though, what we do know is Spencer shoots Fossler dead. Now, Spencer has been charged with that murder. He's been charged with second-degree murder for that. And Mike's question is, why? Why is he being charged, and why are they pursuing that? And then why was the judge so quick to order a gag order in this case? The judge, I believe, ordered the gag order on the request of the prosecution, but because the prosecution felt, and rightfully so, this case was getting a lot of media heat and attention, and people were starting to react to it, and they wanted to kind of control the narrative. I call that kind of BS. But the judge ordered it. Now they have removed it, and that's why we're all hearing about it. This actually took place some time ago. He's going to go to trial soon. Why, though, is the prosecution pursuing this? The only thing I can say is two things. One, obviously, there is a public interest against vigilantism, right? I mean, we don't live in the Old West. We don't string people up from a tree anymore. We don't take justice into our own hands. We live in a civilized society, and we don't want vigilantism. But why this wasn't perceived as some sort of self-defense case, the only thing I can say to that is maybe we don't know all the facts. Maybe there is some evidence out there that this was a little more calculated on the part of Spencer. I don't know if that's true. And I am certainly not trying to defend the prosecution here. All I can say, though, is sometimes it's better for all of us to pump the brakes and try to figure out what the evidence is. But do I think they should be pursuing charges against Spencer from what I know? No. I think they should be handing him a medal and the key to the city. I think that he defended his own daughter. I think that I would have done the same thing, reloaded and unloaded my gun on that man again. I don't think there's a father on this planet who in any way would ever convict this man. Good luck, by the way. Pursue it all you want, prosecution. Good luck finding 12 people, good-hearted people, who are going to convict this man. But again, I'm willing to take a breath if you're all willing to take a breath and see what the actual evidence is. Perhaps we got it wrong. Perhaps there's something missing here. Chris says, Aaron, trial date. The trial has been continued and new dates. Pre-trial date is set for December 17th. Please, I hope we're writing this down. Courtroom confidential, folks. December 17th, and trial is now scheduled to begin on January 26th. Okay, so there you go. It's been taking a long time to get to trial too, but we will continue to give you all updates on that case. But I agree with you, Mike. I don't get it. I don't know what's going on. All right, let's keep it moving here. Thank you so much, Mui Mui, Moi Moi. How do I pronounce that? Moi Moi. Is that like the kissy sound? Moi Moi. Super sticker. Appreciate you. All right, and to Mary Jubinville for the super sticker. Thank you so much. To Katie says, could BK have done that, or did he have to say guilty? I mean, here's the thing. It's not so much like that they have a right. They can request it, but the prosecution could say, no, I want a guilty plea. I've done that before. They say, I will tell them, here's the deal. I want a guilty plea. I don't want a no contest plea. They could have told him that that was part of all of it. And maybe they did. I don't know. But yes, the answer is it's an available option to the defense. But again, prosecution doesn't have to sign off on it. All right. Let me see if I got this all correct here. I'm sure that you will let me know if I don't.
Hi, Josh. It's Sue from Sydney, Australia. In February of 2024, a now former Sydney police officer called Beau Lamarre-Condon shot and murdered two men with his police-issued firearm in a domestic violence situation. The two men who were murdered were Jesse Baird and Luke Davies, and they were both in their 20s. Jesse was a young morning TV presenter and an Aussie Rules goal umpire, and Luke was the new partner of Jesse. The accused ex-police officer refused to give any information about where he had hidden the bodies until he was presented with the no body, no parole rule. He then led police to the whereabouts of the bodies, which had been buried in surfboard bags. The no body, no parole rule, also known as Helen's Law in the UK, I believe, is not really used in the US, although I think that Utah did use it in 2021. What do you think of this rule? And do you think that the US will ever use it more in the future? And P.S., I hope you make it down here one day. Thanks, Josh. Bye.
Sue from Sydney, Australia. I hope we make it down there one day too. Sydney, Australia will be on the map for the Courtroom Confidential World Tour coming to you soon. Don't laugh at me, Kaylin. Pack your bags. Get ready. We're starting to plan it. World Tour coming in 2027. All right. This is exactly why I love Sunday Fun Day. First of all, Sue from Sydney, Australia, let's put you on the map. This is an excellent question. And it raises two things. One, a case I've never heard of, which I love to hear about cases in other parts of the world that just don't make it onto the radar here in the US. And two, it brings up a concept I'd never even heard of. So great question. This is why I love Sunday Fun Day. This man right here, his name is Beau Lamarre-Condon. He was a police officer. And then he was involved, and from what I was able to research and read, it was perhaps some sort of love triangle, relationship gone bad. And anyhow, it ends up in the shooting death and murder of these two young men, Luke Davies on the left there, and Jesse Baird on the right. Baird was a television presenter in Australia. He was 26 years old, and Davies was a Qantas flight attendant. He was 29 years old, shot to death by this man, Beau Lamarre-Condon, who was a police officer, and he shot them with his own service weapon. Police are looking all over for the bodies, can't find them, and then he tells them where they are, and they were both stuffed inside of surfboard bags, and they find them in this very rural area called the Tablelands of Australia. All right. Horrible case, still pending, still going to trial. But the interesting thing about it is what Sue brings up, which is this concept of the no body, no parole rule, which is also referred to as Helen's Law. Basically, this law, more accurately, is called the Prisoner's Disclosure of Information About Victims Act of 2020. And what that does is it says it requires a parole board to consider a murderer's failure to disclose the location of the victim's remains when determining eligibility for release. This is very interesting to me. I had not heard of this before, and I thought a lot about this concept. Helen McCourt, who is the namesake of the law, was murdered, young girl murdered in 1988 by a man named Ian Sims. Her body was never located. Sims never said the location. Helen's mother, Marie, led a campaign to say, listen, this is not right. That at some point, as part of the closure, and I hate to use that term, but as part of the healing process, or whatever you want to call it, for victims, it should be at least some sort of way to compel these murderers to say where the remains of their loved ones are. So they did this. They made this law. Now, what it does is it gives a factor to the parole board. In other words, when the convicted murderer, is up for parole, if they have refused to say where the location of the body is, they can consider that as a factor among many. In other words, it doesn't disqualify them. So calling it the no body, no parole is not accurate. It doesn't disqualify them, but it's one of the many things. We just saw the Menendez brothers up for parole. There are many factors that are considered, and this is a factor that can be considered by the parole board in trying to grant somebody parole. And your question is, why don't we have this in the US? And I thought about that long and hard. And I think the reason for it is it would be considered as running afoul of the Fifth Amendment and compelled testimony. The Fifth Amendment says that you never have to give testimony against yourself. And that doesn't end with a conviction, and that doesn't end with being eligible for parole. So in any situation where it looks as though we're trying to compel some sort of testimony, I think the Fifth Amendment would create problems for that. And you can imagine why somebody would have an interest in not being compelled to give this testimony, especially if they have appeals pending. And part of their appeal is, I didn't commit the crime. They don't want to exactly go about saying, well, here's where you can find the bodies. But I thought, you know what, there could be a way they could avoid those issues and still make it, still give some pressure. And that is to make it a benefit rather than a deterrent or a punishment. The way that the law is written in the UK is that it's the failure to do so is a factor to consider against parole. Well, what if you said disclosure of the remains is a factor to consider in favor of parole? Therefore, you're not compelling. You're just saying, hey, by the way, there's this benefit to being paroled if you're able to provide this information. And that might avoid it, because now you're not compelling testimony, you're encouraging testimony. And there is a big difference between the two. But again, something I was not aware of, a concept I really got me thinking, a case I was not aware of. So thank you so much, Sue from Sydney, Australia. Sue, send us some good hotels for our Courtroom Confidential World Tour 2027 coming to you soon. All right, let's keep it rolling here.
Good morning, Joshua. This is Sharon Grant from Rustenburg, Northwest Province, South Africa. My question is, on the Ethan Crumbley case, why were his parents charged of involuntary manslaughter for his crimes with the mass shooting? Is that a normal practice, that if a child is convicted of a crime, that parents get held responsible for it too? Thank you.
Sharon from Rustenburg, South Africa. Let's put you on the map. Rustenburg, also on the second leg of the tour of the Courtroom Confidential World Tour. Thank you so much for the question. Excellent question. Ethan Crumbley, a case we haven't talked about for a while. Ethan Crumbley, involved in a horrible school shooting, took the lives of several different students, 4 different, there they are, Hannah, Juliana, Tate Meyer, Madison Baldwin, and Justin Schilling. Really awful case out of Michigan. But what was remarkable about this case is that for the first time, I think we actually did research into this. It was the first time that parents were not just being held responsible for the actions of their children in some sort of kind of weak-handed child neglect sort of way. There has been parents who've been held responsible for the criminal acts of their kids in that way, where it's like, well, we're going to charge you with child neglect or child endangerment because you made it possible for your child to commit this horrible crime. They were held responsible for the murders themselves by way of involuntary manslaughter, but that was manslaughter of 4 people. In other words, this is direct culpability related to the deaths of these folks, not some sort of collateral culpability. Unheard of. The question you ask is this normal? No, it's not. It is groundbreaking, and there are other cases being pursued similar to it. And I'll be honest with you, I'm a little bothered by it. Listen, we are all beside ourselves, and I encourage and applaud any effort that is made to try to stop this epidemic of school shootings and violence committed by young folks. I get it. And outside the box thinking, I also applaud. But Talk about slippery slopes and dangerous precedent and holding. This is where I have the problem. Put aside the tragedy of this whole thing. You are holding a person criminally responsible for the independent actions of someone else. This isn't a situation where you've got a gang member who hands you've got a, you know, the OG who hands a gun to the young gang member and says, go out and do some work. This is parents had no idea what he was planning. They never tried to say that they knew he was planning this. No idea what he was planning. He goes out and finds the gun. I mean, it's in their home, but he goes and gets it without their knowledge, brings it to school without their knowledge, commits this crime without their knowledge, and now they're being held responsible for it. And it had to do with some clever arguments about the securing of the gun and realizing his mental health and unrest and everything else. Again, just makes me sweaty in the palms to think about it from a perspective of precedent. But the legal mechanism by which they got there was the concept that we talked about earlier about natural and probable consequences. The target offense here was certainly not murder, but the crime that the parents committed was essentially child neglect, not realizing that your kid needed more help, not intervening and being more involved, allowing him to have access to a weapon when you realized he was suffering from these kind of violent tendencies, not properly securing the gun, all of those things. The argument was made that the natural and probable consequences, all of that was the inevitable death of these people. Again, really stretching the bounds, really pushing the envelope of that concept. But that is how they got there. Sharon, thank you so much for asking the question from Rustenburg, South Africa. Are you guys having fun? Are you juiced? Isn't this a great, didn't I tell you that we would have some really interesting discussions today? We talked about Ethan Crumbley and Lamarre-Condon and the Helen rule, the no body, no parole rules, all a bunch of new stuff. A lot about derivative use immunity, and we're going to get into some more of that. Thank you so much, Fala, damn it, for the gift of memberships. Appreciate you being so kind. And thank you so much. Shy Gal says, you were super fabulous on your local LA news with the Menendez brothers. You are a true star. Oh, you're gonna make me blush. That's very sweet of you. Thank you so much, Sonia, for the kind. Yeah, the Menendez brothers were all over the news this last week, and I was all over the news too, talking about it. So, especially here in Southern California on ABC7, they had me. They enjoy hearing my thoughts on that. So, thank you, Sonia. All right, where are we fueling the jet up and going to next? Catherine says, K9 Catherine here. How is it that Josh looks good in every CC color? It's against every fashion rule. Well, Catherine, I will tell you that behind the scenes, Tiffany has vetoed some colors because she feels like they are not too flattering to my rosy Irish complexion. But thank you so much for the kind words. And for the very generous super chat. All right. Where are we going to next? I got to find my place here again. Oops.
Hey Josh, Nicole from Auckland, New Zealand. I've been following the Sarah Grace Patrick case from Carroll County, Georgia. Following her arrest, I was expecting a bond hearing or a prelim hearing to be held relatively quickly. It does appear that Court TV and another local agency is looking to have cameras in the courtroom. Just wondering sort of what's the regular speed for these types of things. Cheers, awesome, love the show.
Nicole from Auckland, New Zealand. Again, another place I've never been and I would love to go to. Let's put you on the map. Excellent question. Britt Black says, great show today. Thank you so much. I agree. And it's all because of the wonderful questions that you guys are asking. So Nicole from Auckland, New Zealand wants to know about the Sarah Grace Patrick case and what is going on with the timing of all of that. How quickly do these things have to take place? a bond hearing and a parole, or not a parole hearing, but a preliminary hearing. And that's a great question. And I thought long and hard about this. And I decided to be lazy because I have resources at my fingertips. And I said, instead of me looking it up and finding the answer for you, I can always phone a friend.
Nicole, thanks for your question. The state has 14 days for an in-custody felony defendant to be brought for a probable cause hearing. If they're not brought within 14 days for a probable cause hearing, the remedy is that they'll be released ROR, what we call on their own recognizance. Functionally, though, what the state may do is if they have multiple charges, they know they're not going to be ready within those 14 days, they'll induce the defendant to either waive their entire right to a hearing, or if they'll waive the right to the 14 days, they'll reduce their bond. It's very enticing to a lot of defendants because what happens is that they won't have enough money to make their bond. So that enticement to then waive that right is very big in their minds, because that means that they can effectually get out of custody. If the defendant is brought through an indictment, though, that's where the state will present that through the grand jury. There's no preliminary hearing in that case. The state will present that case to the grand jury. Grand jury will decide what charges to indict on, and then they'll issue what they call a capias, or kind of like a warrant for their arrest. Once that warrant is served on them, they will have to post bond, and if not, they will be in custody until that case is brought to trial. The trial rights is very tricky in the South here, because through that indictment process, an individual can sit for a year, 2 years even, depending upon the timing of their case. Some of these counties, they don't have a lot of attorneys because we have an appointment system here. What that means is that they don't have a huge public defender system, so then independent criminal attorneys are appointed. Sometimes these small counties, there's just not enough attorneys. So they'll sit and wait to maybe sometimes even get an attorney. Once they get an attorney, they'll have to wait until that circuit judge, because that's the only judge that can hear these cases for trial in the South, that circuit judge will be sitting on the bench to hear that. Some of these counties, they only sit even once a month, once every 2 months. You can imagine people that have been waiting for that long, their cases will get priority. The people that have the unfortunate luck of being behind them will have to just sit and wait until they get their trial. It's a tough system. Thanks.
That is my good friend Craig Rouvier. This is the story on Craig. Craig and I were, and that's where you can find him at thecraiglaw.com. Craig is now in Nashville, Tennessee. But Craig and I were DAs together here in Los Angeles. I've known him for a very long time. He's a very, very good lawyer, very bright. But he was here in Los Angeles as a DA, and he said, I'm done. I'm tired. And I'm sick of California. And he packed up his whole family and he moved to Nashville, which is a lot of folks from California moving to Nashville, moved to Nashville, Tennessee, set up shop as a criminal defense attorney. And we have stayed in touch, obviously. And it's been giving me this real eye-opening insight into how the law is practiced differently in all the different states. And he can tell me some wild stories, because it's just different when you're dealing with kind of more rural communities where they don't have a bunch of attorneys. You know, I'm used to Los Angeles. There are way too many attorneys, thousands of attorneys. He's working in areas where they have a hard time finding defense attorneys. He's working in counties where there might be only 2 attorneys that they can appoint cases to. So when he shows up in that county for whatever reason, they'll just start throwing cases at him. Will you take this case? Will you take that case? And it's creating this huge backlog and bottleneck effect. But to the question that Craig answers, the speedy trial rights is what we're dealing with here. Those all come from the 6th Amendment. Whenever you hear about these 6th Amendment or rights that come from the amendments to the Constitution, you have to realize that each of these amendments are only about a sentence long, okay? And it's out of these few words that we have then, over years and years of case law through the Supreme Court, decided what these things actually mean. But the 6th Amendment says that you have a right to a speedy and public trial. That's all it says. It doesn't tell you what speedy means. Years and years and years later, we've decided what speedy means. Federally, and usually each state has in their laws what speedy means. In California, it's incredibly strict. You have 48 hours from your arrest to be arraigned. You have 10 days from your arraignment to preliminary hearing. You have 60 days from your preliminary hearing till trial. If you don't waive those rights, that is how quickly everything can happen. Within 70 odd days of your arrest, you're going to trial. We have decided that's what's speedy in California. Well, in Tennessee and in many parts of the South, they don't have all the resources, and they decided that speedy means something else. The Supreme Court, the famous case of Barker versus Wingo, established a test, and is what is called a balancing test. And basically what it means is you have to look at things like the length of delay, the reasons for the delay. If the reason is we don't have any attorneys, that's a pretty good reason. The defendant's assertion of the right, in other words, has the defendant ever waived their right at any point? And the prejudice to the defendant. Well, the prejudice could be horrible. I'm sitting in jail all this time, but weighed against the reasons for them sitting there, as long as it's not an unreasonable delay because they're just sitting on their hands, people can sit there for a long time. He just told me he has cases with people in custody that he's trying to set the trial, and the earliest trial dates he's getting on these is May of next year. So don't commit crimes in Tennessee is the full takeaway from this, unless you can post whatever that bail is. And if you can't post the bail, what is it? If you can't pay the something, don't do the crime. You can't do the time, don't do the crime. Whatever it is, stay out of trouble. But thank you so much, Craig Rouvier. Like again, if you're looking for an attorney and you're in the Tennessee area, check him out, thecraiglaw.com. All right, let's keep it rolling here.
Dear Josh et al., I hope this letter finds you well. Put on your prosecutor hat. Yes, the one that smells like moral conflict and budget coffee, and let's play pretend. In the Arkansas case against Aaron Spencer, if you were the DA, what would the internal monologue sound like? What possible train of thought leads someone to say, yep, this is the hill we're dying on? What factors might you consider to justify bringing charges? Indulge us with a glimpse into the mind of a prosecutor trying to sell this to a jury. Sincerely, a therapist you know in the Midland area of West Texas.
Therapist you know, so good to hear from you. Midland, Texas. Put on your prosecutor. What was it that smells of conflicts, moral conflict and bad coffee, cheap coffee? I got to remember that one. That was good. Yes, the Aaron Spencer case, again, a case that's, oh, look at that map. Look at that. What are we doing in the kind of mountain desert areas right there? We got to get the Wyomings and Dakotas involved here. Anyhow, great question. What would I do? How would I rationalize this? And how are the DAs rationalizing this on the Aaron Spencer case? We talked about this a little bit before, but it's good to revisit this again, if for nothing else, to see this man's beautiful turkeys. It's a tough one. I would like to say, if I were the DA and I was assigned this case, I would be in my supervisor's office, pounding my fist on the desk saying, what are we doing here? We got to get out of this. We got to dismiss this. This is not right. This is not the pursuit of justice. Here's the thing, though. Somebody lost their life. Okay. That person who lost their life is a allegedly horrible human being. And I'm saying allegedly because it's the right thing to say, but we can say a horrible human being. But that is not the way the law views it. The murder laws do not say the unlawful taking of a good human being is murder. every human being, whether they are the biggest POS in the world or an absolute saint, it's murder. So someone lost their life. It is a homicide. Now we got to figure out what that is. Now it could be a justified. In other words, it could be a self-defense homicide. We don't pursue those. If we believe that there's a righteous self-defense, we don't pursue that. I don't know, though. Again, is the prosecution aware of things that we don't know? Imagine this scenario. Imagine if Aaron Spencer pulls over Fossler. That's his name, right? Fossler in his car. And Fossler says, okay, you got me. You got me. I'm getting out of my car. I will surrender. You can take me to the cops. And Spencer just blasts him in cold blood. Are we okay with that? Are we okay with that because of who Fossler is and what he did even that evening? That's not self-defense. Not even on the books is that self-defense. And do we want the prosecution taking it upon themselves to just nullify crimes because they're okay with it? Also not a place I'm all that comfortable with. I don't know the facts and circumstances of it. If the facts and circumstances are that Fossler charged at Spencer, this is a full stop wrong. If the facts are that even Fossler tried to keep Spencer's daughter in the car, then full stop wrong. I think this is a bad prosecution. But maybe there's something we don't know. Putting all of that aside, I think another thing the prosecution has to really consider here is: who's gonna go for this? You got to put 12 people in the box. You're gonna find 12 people who are not going to feel exactly like we all feel about this, and just be like, not only do we find you not guilty, but we'd like to give you an applause, and can we buy you a drink? I mean, this again. Prosecutors have to prosecute cases even when the people who lost their life are bad people. But I really hope there's more here to this that we don't know about, because otherwise it just sounds like a really, really bad prosecution. There he is. Jury nullification, exactly, says Kathy. All right, great question, therapist. Hope I answered it. And I hope you're still watching. All right, let's keep it rolling here. Not my fault. I'm pressing buttons, Kaylin. Kaylin yells at me, everybody. She's going to write. She writes with this all.
Happy Sunday, fun day, Joshua, Tiffany, Kaylin, mods, crew members, guests, everyone. Felicia K. Mayo, Humboldt, Tennessee. Oh, I hate to ask a question about Granny Gotti, but Joshua, I got to know. Donna Adelson, do you know, has the state checked on the accommodations that Donna and Harvey had set up for their little jaunt to Vietnam? I would think if it was short term, that might help Donna out. And if it was long term, definitely help out the state. Thanks. Hope y'all have a great Sunday. Bye.
Alicia K. Mayo from Humboldt, Tennessee. It's amazing how immediately I hear your voice and I know Humboldt, Tennessee. Calling and asking a question about Donna Adelson, also known as Granny Gotti, also known as the murderous matriarch of Miami, which is the term I'm coining that I would like to put into the zeitgeist. What a interesting way of thinking about this. She had a one-way flight to Vietnam. Did anybody look into their accommodations there to see if they were long-term or not? I don't know. The answer is I don't know. And I looked and I couldn't find anything on it, but I think that would have been a very smart thing to do. If they are put down a 1-year lease on a home in Vietnam, it's very different than if they got 3 nights at the Hyatt, right? I mean, it would, and you would think that the defense probably would want to know too, which more than anything probably makes me think the defense did ask her and the answer wasn't great. I'm sure that they thought about this and thought, well, listen, you probably had a hotel, right, Donna? Right? You probably had it for only a few days, right, Donna? Right? No, I put a 5-year lease down on a Airbnb because we weren't planning on coming back. It was likely the answer and why we don't know about it. But a excellent question. Alicia K. Mayo from Humboldt, Tennessee. See, this is why I love this. You guys always come up with the clever stuff that I haven't even ever thought about. All right, let's keep it rolling here. Where are we going to next?
Hi, Courtroom Confidential. This is Sonia from Chicago. And my question is about Grandma Gotti. And my question is actually more about Georgia and what her plan is. So Donna was arrested at the airport and she was on a one-way ticket. So they had no choice but to bring Donna in at that time. So my question to you is it possible that the plan was to do Wendi and then Donna and then Harvey? But it got messed up with her trying to leave the country. So that's my question. Thanks, everybody. Have a great day. I love Sunday Fun Day.
Sonia, we love you. Sonia from Chicago, Illinois, always coming in with the great questions. Again, talking about Donna Adelson, Grandma Gotti, the murderous matriarch of Miami, patent pending, and Georgia Kappelman. So, again, another interesting thought on this case that I had not thought about. Is it possible that Donna ruined their plans by leaving the country and them necessitating them to arrest her sooner than they had planned? I think that's very possible. I mean, they arrested her at the airport, right? So obviously, this did not seem like what would have been an otherwise planned arrest. I imagine they became aware of the fact that she was leaving the country and they had to move quickly and they got warrants together and they went out and they got her at the airport. Now, one thing about that is they may have decided to go ahead and wait for her to get to the airport because it further, seals her fate in that she was trying to flee. It would be one thing if they arrested her and she's got the tickets on her and she could have argued, well, I wasn't going to use those tickets. She's at the airport, passport in hand. She's about to leave the country for good, everyone believes. But I do believe that her travel plans hastened their timing to actually arrest her. And could they have hastened it enough that they messed up the order in which they wanted to make arrests? Could also be. I don't know. I feel, though, if you're following the plot, it does seem as though the prosecutions have started from the murder and worked their way out. And it sounds like if you're following this chain and you believe that everybody's involved, that you would go from Rivera and Garcia, the actual hitmen, work your way out to Meg Benoit, the in-between, work your way out to Charlie, the money man, work your way out to Donna, the green light, and work your way out to Wendi, the impetus for all of it, right? But I don't know. Maybe they felt that they continue to have Wendi testify. So maybe they also wanted her available for Donna's trial. I don't know. But I do think you would make an excellent point that they probably had to scramble and make an arrest earlier than they planned on. And there she is, Georgia Kappelman. Making a career out of this one case is incredible to me. And she's doing an beyond admirable job. And that's a great photo of her there. All right. Thank you so much, Sonia. Pardon me. Let's keep it moving here. Let's keep it rolling before my voice gives out on me.
Hi, Josh and crew. My name is Gisela Kay from Grizzly True Crime. And for the map, I am living in Switzerland in the canton of Zurich. And my question for you today is, you are a criminal defense attorney with a private practice, but now you're also a very popular law tuber or YouTuber with your own channel, Courtroom Confidential, which is amazing. So my question is, has your YouTube channel and the reach that it has that impacted your private practice at all? Meaning, has it made it even more popular? Do you have even more clients demanding your time and energy, or has it not had any impact on that at all? Thank you so much, and everybody have a wonderful day.
Gisela, I hope you're still listening. I hope you're on your jog and you're hearing your question come up. I love this because as soon as you hear Gisela's voice, all of a sudden the chat lights up with a bunch of grizzly bears. Pardon me, guys. And a great question. Gisela from Grizzly True Crime. By the way, Gisela is going to be going live, I think, right after us today, talking about the Emmanuel Haro case. So don't go anywhere. Sorry, she says, I am indeed. Don't go anywhere. Stick around. Watch her talk about the Emmanuel Haro case. Horrific, horrible, horrible case. I'm going to be watching because I know that she's done a deep dive and I'm curious to hear the information that she's found. But this is on the young baby who the parents said, she was knocked out at a Big Five parking lot and wakes up and the baby's gone. And we all kind of knew it was headed in this direction, sadly. And now they have been arrested. The mother and father of poor Emmanuel, and he is likely suspected to have lost his life. So check that out. Gisela's going to be doing that. But Gisela wants to know, calling from Zurich, Switzerland. First of all, let's put you on the map by way of South Africa. Has the channel affected my law practice? Sorry, I hope this goes away. The answer is yes, but not really. I am still practicing law, but it's not like I am flooded with a bunch of calls, which is totally fine with me, by the way. Not the purpose of doing this channel and not something I was even hoping for. But I do get interesting calls from all over the country, which doesn't exactly translate into work for myself. I've been able to refer some things out. I'm not like hopping on planes and hopping all over the country to handle stuff. But I will say it is helpful in a different way. I don't think that I've got a bunch of calls because people are watching my channel and go, oh, I need that attorney. But people, I don't do any advertising. So most of my clients come to me by way of a referral from some other lawyer or some other person. And people do, when they get a name on a referral, what they always do is they Google that person before they call them. And when you Google me, you get a bunch of stuff, including the channel. So I have had people who come in to meet me and they go, oh, and by the way, I saw your YouTube channel or I've seen your podcast and very cool. So it had a net positive effect. But thank you, Gisela, so much for asking that question. What a fun kind of treat to hear from you. And yes, it's a lot of worlds colliding. And hopefully this channel takes off enough that I'm not even doing all that much legal work anymore. Because I'll tell you what, it's exhausting and it's draining. And I'm in the mood for a change in my life. So anyhow, thank you for that, Gisela. Gisela K, ever heard of her? She's got a YouTube channel of her own that you may have heard of called Grizzly True Crime. You guys should check it out. Net positive effect, says Gisela. Thank you so much, my friend. All right. Let's keep it rolling here. Apparently, I was allergic to that question, but now I'm feeling better.
Hey, Josh. Happy Sunday Fun Day. My name's Jack from Hamilton, New Zealand. Long-time listener. Love your content. You are such an orator, and I look forward to when you're live and also watching replays. Thank you so much for what you do. My question is regarding Stephan Stearns and the thousands of images of him SAing Madeleine Soto. I want to know, how does the courts prove beyond a reasonable doubt to jurors all of these charges? I'm sure most rational people wouldn't want to see the images, but it must be unfair on the defendant if jurors are giving verdicts without actually seeing the evidence and, taking the prosecutor at their word. Does every single juror need to view all of the images to give the guilty verdict, or how does the court system get past that barrier? Another question I have is about the Kohberger case. Can you please play devil's advocate and jump into the mind of Bill Thompson, the prosecutor? He says he doesn't want to victimize the family of the victims anymore. But isn't the courtroom the one place where the families are meant to get justice? Why didn't he just ask to tell us where the knife is? Just the absolute basics. I do not understand why he kept going on about that. Thanks, Josh. Huge fan. Cheers.
Jack, so good to hear from you. Hamilton, New Zealand. Thank you so much for being a longtime listener and first-time caller. There you are, my friend. Appreciate hearing from you, and some great questions too. Oh, wait a minute. Let's zoom out there. I know that's where Hamilton was. All right. I feel you, Jack. I feel you. Why didn't he just ask where the knife is? That's the one that kills me. Is, you could go back and forth on what do we want to hear from this man about his motives? What do we care? Does it get us any closer to having some sort of catharsis at this whole thing? Why give him any kind of further platform? Why give him an opportunity to have a forum and a pulpit and all of that kind of stuff? I get it. I'm not saying I necessarily agree with it, but I'm saying I get it. But I don't get why you don't ask where the knife is. Tell us that one, buddy. You know what that would have done? As I'm sitting here thinking about it, what that would have done is to a question we talked about earlier about the no body, no parole. What that would have done is really locked in the idea that this man is never going to try to appeal this. He's waived his rights to appeal. I don't want to rip off the Band-Aid to that old wound again. He's never going to appeal, but you got a person now telling you where the knife is, where the murder weapon is that no one could locate. That's some pretty convincing evidence beyond even their plea in court that they were involved in this whole thing. Why didn't he do it? I don't know. I don't know. I will say this, though, in the defense of Bill Thompson, I like this man. I think this man really cared about this case. I have taken many pleas in my life, and I have not sat down with the defense and said, well, I want to know X through Z on this whole thing. Usually it's enough that they're taking a plea. So I'm not trying to say that this is something that is routinely in practice, but in this case, this is different. Everything about this case is different. And there's a lot of still unknowns about this case. And I get it. Tell us where the knife is. Just that. Give us that alone. But our understanding is they didn't even ask. But your other question is about another horrific case, Stephan Stearns. And would the jurors have actually had to sit through all of the horrible images of assault? And the answer to that is yes. They have to see this evidence. He's being charged with this, and this is the best evidence of that crime having taken place. They would have had to see it. And these types of trials, I will tell you, are incredibly difficult. They're difficult for everybody. I have not, as a prosecutor, really prosecuted these types of crimes. I didn't get into a lot of essay type stuff or stuff with children. That's a specialized unit that I was just not a part of, but I assisted in things like that and been in court for the presentation of some of this type of evidence. And they will close down the courtroom. They will remove the audience many times for these types of things. And they will go, but they have to show some of this evidence. And the jurors, they need a break. Many times I've seen jurors break down. I've seen them ask for breaks. I've seen it take a long time. Now, that all being said, the prosecution doesn't get gratuitous with it. They usually just present enough to establish the elements of the crime. They're not trying to show thousands of images, thousands of hours of videotape, but they have to show this stuff, and it's horrific stuff, and the jurors do need to see it. It is important that they know the evidence before they convict someone. You can't just say, I would show you this, but it's very disturbing, but let me tell you what it shows. And that is even in spite of what the defense may say. The defense can't stipulate to this type of stuff. It's important that that stuff is done in court and jurors are making their decisions based upon the evidence, not what we're telling them the evidence is. Great question, Jack. Say hello to all my friends down there in New Zealand. Appreciate all your support. All right. Helen Scottish Llama says, one-way ticket, open jaw, or around the world tickets. Yeah. What do we ask here? Wait a minute. Are we talking about Donna or are we talking about our world tour? I'm not sure here. Open jaw or around the world tickets. If we're talking about the world tour, what are we talking about, Kaylin? Is it the world tour? She says, I don't know. Anyhow, stay tuned for Courtroom Confidential World Tour 2027. Tiffany's had enough stress just getting us to Denver for CrimeCon. The idea of us getting on a plane for a world tour, I'm sure, would give her fits, which I'm not saying I'm opposed to. I'm just saying it would give her fits. All right, let's keep it rolling here. I just want to make sure I'm doing this in order. All right.
Hi, Josh. This is Sherry from Carmel, Indiana. I have recently become a fan after watching your interview with Lauren on Hidden True Crime. You have possibly become my #1 favorite. Just don't tell anybody. Appreciate what you're doing and how much interaction you give with your fan base. And this crime came to mind for me. It took place when I was about 10 years old. I thought you might be interested in taking a look at something from way back. Took place in Ogden, Utah in 1974 and has been named the Hi-Fi Murders. I was 10 years old at the time, and now that I think about it, I can't believe my parents weren't a little more aware that this was information that I was interested in, and there was a book written on it that I probably read when I was 11 years old, but I cannot imagine my kids being this immersed in something like that. But anyway, check it out. Thanks again for everything you do, and let's keep this rolling. Kaylin, be patient with Josh. He's doing the best he can.
Thank you, Sherry. Thank you for that. I'm trying here. Sherry calling from Carmel, Indiana. Kaylin's beside herself. Well, then don't yell at me all that much. All right. Sherry, again, this is one of the reasons why I love this Sunday Fun Day, because so many things are brought up that were never on my radar. And this is one of them. Thank you for asking. And you mentioned that there's a book on this case. If Sherry's watching, or you can let us know, I would love to know what that book is. I had not heard of this. This is referred to as known as the Hi-Fi Murders. I'm going to tell you guys up front. I'm going to give you the strongest of graphic content warnings coming up here, because this is a really horrific case. I'm not going to get overly detailed about the whole thing, but I do want to tell you about this if you want to look into it further. And I actually watched kind of a miniature documentary on it last night because it's stuck with me since I started to read about this thing. And this is apparently a case that they teach at the FBI when they're talking about the concept of mass murders. This took place in Ogden, Utah, back in April 22nd of 1974. Several men, there were only 3 men who were ever arrested and tried for this, but there were more men involved, as many as 6 men. Don't break into, they go into the hi-fi shop in Ogden, Utah towards the end of closing, towards when they're about to close, with the idea of committing a robbery. And things go, whether you want to say it was pre-planned or not, but things go incredibly, horribly wrong. 5 people are taken hostage. 3 of those people end up murdered. Even though they intended to kill everybody, 2 people actually survive. But Stanley Walker, who was 20 at the time, Sherry Ansley, who was 18. It's amazing to me, these photos of them, they look much older, but they're only 20 and 18. And then Carol Naisbitt, who was 52 at the time, all tragically lost their lives. The 2 people who survived, we could not find pictures of them, were Byron Naisbitt, who was Carol's son. He was 16 at the time. He survived a shot to the head. And Orrin Walker, who was 43 at the time, who also survived a shot to the head, including another injury, which I'm going to describe to you. But in the course of this robbery, it's a hi-fi, it's a store with electronics, hi-fi equipment. They want to rob the store. They have a van. They are actually all members of the Air Force. There was an Air Force base nearby. They are United States Air Force servicemen. They got together and they decided it would be a great idea to rob this liquor store, or pardon me, this hi-fi electronics store. They go inside, they tie everybody up, they put them down in the basement. And then they decide, well, we don't want to leave any witnesses. And the way that they first decide to kill these people is beyond diabolical. One of them goes and retrieves from their vehicle a bottle of Drano. And there is some evidence that they may have been inspired by a recent movie, but they force feed the Drano to everyone. The Drano causes immediate blistering and burns to their lips and mouth, and everybody is having incredible internal injuries and responding to this and coughing and throwing up and everything else. Force feeding these people. They're watching one person drink it, and then the next person's reacting to it and they have to drink it. They're telling them if they don't drink it, they're going to put a bullet in their head. They thought that this would kill them. It does not kill them. They all survived this. Orrin Walker, who was one of the people who survived, was smart enough to drink it and then react in a way as if it were affecting him as he let it out of his mouth. It still burned the inside of his mouth, but he did not actually drink it down. When that wasn't enough, one of the men, Dale, and by the way, I didn't name these men. The men who got convicted was Dale Pierre Selby, along with William Andrews, who were both convicted for the murders and received the death penalty. They were both executed. And then Keith Roberts, who received 13 years, but he was only the getaway driver outside. He ended up actually dying by suicide after he was released from prison. Anyhow, Selby, Dale Pierre Selby, is kind of the most brutal and sociopathic and the one kind of behind the whole thing. He then takes Sherry, 18-year-old Sherry, and brutally assaults her sexually over the next 30 minutes or so. And then when he was done with that, he puts a bullet in the back of her head. All of them are lined up because their deaths aren't happening quick enough, and a bullet is put into each of their heads. Stanley, Sherry, and Carol lose their life that way. Byron, like I said, is shot in the head, but it not clear enough. It grazes off of his skull, and he survives that with incredible injuries and disabilities from that point forward. And Oren is also shot in the head, and he also survives. But a coup de grace on Oren, and no reason ever provided for this was, and again, graphic warning, don't say you weren't warned, but they decided to put a pen into like a ballpoint pen into the ear of Oren and then kick that into his head in the attempt of actually trying to kill him that way. And it didn't. It ends up going through his ear canal and out of his mouth, to the point that he is, when officers arrive and he starts to speak to them, they can see the pen moving. They thought the pen was actually behind his ear, like a person might hold it, and instead it's actually through his ear. So they're caught quickly thereafter. Quickly. I mean, there's surviving witnesses. They're able to give a description of the people, a description of the car. There's, people talking, people start to talk. They said that they were planning to rob this store. They go to the naval. I mean, it's like they caught these guys within days. They're all, like I said, the 3 that they were able to identify are convicted, and 2 of them actually do receive the death penalty and were executed while they were in prison. So horrible case. One that I'm shocked that I hadn't really heard of before now. Sherry, thank you so much for kind of giving us all nightmares, but also for bringing forward an important case for those who follow this type of stuff. And again, if you know the name of that book, I would love to see it. Victim. Oh, well, there you go, says Sarcasm. You want to know? Here you go. Victim, The Other Side of Murder by Gary Kinder is the book, one of the first true crime books ever written. Oh, very interesting. I'll have to check that out. Gary Kinder. I wonder who that person was or what their association was with this. But just people shopping at a hi-fi shop, looking for stereo equipment, and all of a sudden lives are forever changed. Yeah, it's safe to unmute now. Sorry about that, guys, but thank you, Sherry. Appreciate that. All right. Let's keep it moving here.
Hey, Josh, it's Kathy from Brunswick, New York. I have to do this quickly before the court starts talking again. But with all that's happening with dear Donna Adelson's defense this afternoon, could that possibly be grounds for ineffective counsel? Thanks. See you Sunday. Bye.
Kathy from Brunswick, New York. Always so great to hear from you. You asked about Donna Adelson's case, and I wanted to say that I think somebody else asks about this. Oh yeah, we do get another question similar to this. So I'll kind of share my thoughts halvesy here and halvesy later. But Kathy asks about the Donna Adelson case, and is there a problem already mounting with the defense, and are they looking at a ineffective assistance of counsel? I know that there was a strong back and forth with the defense and the judge about objections being made to the introduction of email evidence, and the judge kind of, the big teddy bear of a judge, Stephen Everett, kind of lost himself and said, why didn't we? I thought we handled all of this. What's going on here? Do I need to excuse the jury? And he's getting a little upset with them, and they're kind of digging their heels in. The answer is this is more theatrical than it actually is as far as being problems for the defense. The ineffective assistance of counsel is really difficult to prove. I mean, you essentially have to be asleep at the wheel. It's not just judges getting angry at you. It's not even making mistakes. Is there something that you did that is so bad that no reasonable attorney would have done it or not done it? In other words, did you miss doing something and it's so bad that no reasonable attorney have done it? And did it actually prejudice the case? And that's where it becomes the most difficult part to prove, is was there anything about this interaction with the judge that actually prejudiced the case? And they don't have the IAC is incredibly difficult to prove, and it doesn't happen all that much. But yeah, there's already fireworks. It's not even a full week yet, and already the judge is kind of getting a little frustrated with the way things are going. But I think the ship has been righted. The train is back on the tracks. I don't think we're going to see a lot more of that. But we'll talk again a little bit more about where that was all coming from in a later question. That big old teddy bear showed his grisly teeth, in my opinion. He let them know there will be no shenanigans allowed. It is a no shenanigans zone. That is that is a behave yourself look right there. That is, I am not taking your shenanigans. Love this guy. All right. Great question, Kathy. Thank you so much. Let's keep it moving here.
Josh, hi. It's Pilola's mom from Maniloki, New Jersey. It's a beautiful Friday, and we are watching Donna Adelson. And the question I have is regarding the children. Yes, they were very young when their father was killed, but they also may have a memory of Donna saying bad things about their dad, or even Wendi saying bad things about their dad. I know that they've had their name changed since the unaliving, and I'm wondering if either side can call them as witnesses just to testify that, yes, Donna said derogatory things about their father, or Wendi did when they were growing up, or are they still too young? And if they're not able to testify by either side, is it something that defense would do um, for sake of if she does get found guilty, that they'd be able to come forward and do like the whole don't give my grandma the life without parole, or something, so that they can see her again? I'm just curious because we don't really have any information on the children other than Donna was so nasty about.
Pilola's mom from Maniloki, New Jersey. Sorry that you got cut off there at the end. Always love hearing from you. Let's put Maniloki back on the map on the Jersey coast there. Great question about the children here. Well, let's get to the technical answer first. Could they be called as witnesses? Yes. There is nothing that prevents children from being called as witnesses, and oftentimes they are called as witnesses. The more important question, look at how young they were there. The more kind of pertinent question, though, is how would they benefit either side by calling them as witnesses? And I think you're only really talking about the prosecution calling them as witnesses. Could they call the kids to talk about Donna saying awful things or Wendi saying awful things about their father? I suppose that they could. They were very young at the time. I think they were 3 and 5 at the time that their father was killed. So they are now still young. They're still juveniles, even 11 years later. So one, do you really want to put young people through that who've been through so much already? Do you really want to be asking them about things from their memories that they probably can barely remember anyways? And what value does it actually bring to call them? Would it be seen as a little exploitive to put these children on the stand? I think so. Do they actually have evidentiary value? Probably, but probably very little. Are you really going to have these poor kids testify against their own grandmother? I mean, a lot of kind of other than can you do it, the kind of why would you want to do it questions start to come up. But to your point, Pilola's mom, I do think the possibility of them being called at sentencing might be interesting. And who would they be called by? I mean, you know, the prosecution would want to hear perhaps about the devastation of not having a father, growing up without a father. Again, tough thing to put kids through, just to talk about how the sadness that they're going to carry with them for the rest of their lives? Or would the defense want to call them to say, grandma has always been great to us, and please don't put grandma away in prison for the rest of their lives? Again, a little exploitive, especially when she's probably looking at, if convicted, a guaranteed sentence anyways. So yeah, I'm glad that you brought this up, though, Pilola's mom, because they are the real victims in all of this. Their father's the named victim, but they are victims who are going to have to continue to live with this. It's just so, being a father myself, the idea of my kids having a life without me is so, it troubles me so much. I mean, it's one of the reasons I try my best to take care of my health as much as I can, because I don't want them to ever have to experience that. And the idea that these poor kids did nothing wrong but have some psychopaths for grandparents and uncles, perhaps mothers. And now they have to live the rest of their life, not only without their father, but then with their other family members going off to prison. And then, I don't know how much they know about this, but one day they will be old enough to learn this whole history. Anyhow, thank you, Pilola's mom. Excellent question. Thank you for helping us remember what's really important about all of this. All right, let's keep it moving here.
Good morning, Josh and the CC crew. Happy Sunday Fun Day to all. My question's over extradition and why would someone fight it? I know that there are advantages in fighting it, in that it can limit the charges that someone faces. So, for example, from reading Nicholas Rossi's decision from the Sheriff Court in Edinburgh, that he cannot face any other charges other than the 2 in Utah without having to come back to the Scottish government and getting permission to add more on and more cases on. And I know that if someone is extradited from the UK to a country where the death penalty is, that the death penalty has to be taken off the table because of the European Convention of Human Rights, and one of the additions to that, which is about ending the death penalty. But what other reasons are there to fight extradition like Kimberlee Singler is doing in London? Thank you. Bye.
Thank you so much, Helen. What an excellent question. I have one criticism, and that is we did not know where you are from, but I am going to say you are from somewhere generally in the UK. So there's the UK. We're saying our suspicions are that you come from somewhere in there. But excellent question. You're in your bio here, you have yourself as the Scottish llama. So I'm gonna guess somewhere in Scotland. Anyhow, great question. Why is, and this is another case I was not all that familiar with, Kimberlee Singler. Why is she fighting extradition so hard? And you named a bunch of reasons, which are actually, I think, just the best reasons. So if there's reasons to fight it beyond that, I don't think there are many. But for those who don't know about this case, back in December of 2023, Kimberlee Singler is from Colorado Springs in Colorado. She makes a 911 call about a burglary in her home. Officers arrive to find that the 2 of her children have been killed. Eliana, age 9, and Aiden, age 7. Beautiful kids. How people can do this stuff is beyond me. They have been, there's a bloody handgun and a knife. A third unnamed child survives. They find DNA evidence linking the bloody handgun and knife to the victims and to Kimberlee. And she, at one point, it looks like trying to blame her husband or something, but then her story falls apart because he's got a rock solid alibi. And she flees to London, and they find her and arrest her in London, and they're holding her there, and extradition proceedings are pending, and she's fighting it tooth and nail. So I don't know a whole bunch more about the case because she hasn't gone to trial and because she hasn't been brought back to the U.S. And there hasn't been a lot of reporting on it because most of the reporting has been on how she's trying to fight extradition. And Helen's question is, why is she fighting it? Well, you listed a lot of the reasons. She's fighting it because she doesn't want to come to an American court, which is likely going to treat her less friendly, I think is the diplomatic way of saying it, than the sentence she might be looking at in the UK courts. In the US, she's looking at probably life without parole. And in the UK, she would likely not be looking at that. But I mean, the real reason is the UK can't prosecute her. She didn't commit a crime in the UK. She's committed a crime in the US, and the US wants her back. And she's saying, well, don't send me back because prison conditions are awful in the US and they want to give me life without parole. And she's trying to call upon kind of the sentiments of the Human Rights Act of 1998, which really only apply, as you pointed out, Helen, to situations where the extraditing country may not agree with the potential of the death penalty in the country that is requesting the extradition. But I mean, also, I think some of it has to do with delay. Some of it has to do with desperation. It may have a little bit to do with plea negotiation. And by that, I mean, she may be saying to prosecutors here, I'll waive extradition if you take life without parole off the table, if you're willing to sentence me to something less than that. But they're going to say, no, thanks, lady. We're sending you back over here and we're going to prosecute you to the fullest extent of the law because you killed 2 out of your 3 children, and it looks like you tried to kill the third. This third was severely injured but managed to survive. So horrible case. Horrible case. Again, I don't know much about the motives behind it, why, the planning, whether it was spur of the moment, whether she lost her mind, but whatever she did, the state of Colorado believes she killed her kids and they want her back. So thank you so much, Helen. Just tell us where you're from, Helen. If you're in the chat, give us a shout out. All right. Let's keep it rolling here. Oh, boy, guys. It's coming down to the last few questions here. Have you had fun? Are you juiced? Have we provided you with enough juice fuel this morning? We talked about the high-five murders. If you were able to survive that one, a lot of Donna Adelson, a lot of Wendi Adelson. Got into Ethan Crumbley, Beau Lamarre-Condon. I mean, we covered a lot of ground this morning. And we're down to our last few questions here. All right. Let me make sure I'm doing this all correctly here. Who did we just hear from? Helen. All right, here we go.
Hello, Josh, CC crew and mods. It's Joy W. from Ottawa, Canada, calling. I have come to the realization that I like all the nitty-gritty basic rules of court and trial and evidence kind of thing. So my question is about foundation. Now, this topic came up in the Adelson case recently, and I think I understand it, but I just like to understand it better. So what exactly is foundation? How do you establish it? And when do you need to establish it? Thanks for answering my question. Everyone have a great Sunday and the rest of your week. Bye.
Joy from Ottawa, Canada. I love that you like the nitty gritty because I like the nitty gritty too. And what a great question about foundation. What is it? What is it meant? What is meant by it? How is it established? Foundation is, what's the best way of answering this? Foundation is kind of establishing the bare minimum to allow for the admission of evidence. Okay. Foundation, lots of evidentiary issues, you know, some go towards relevance. Some go towards, you know, weighing the factors of probative versus prejudicial value. And so you have all these kind of objections and evidentiary rules dealing with things like relevance, prejudice, all of that. But then you also have things dealing with just the pure idea of can you establish the thing that you're going to introduce is that actual thing? Can you establish the foundation of it? It has to do, you see it many times with documents. People will try to, I would like to admit people's number 13, which is a parking ticket. Foundation. Objection foundation. And what is that saying? That is saying, you're saying it's a parking ticket, but have you established to the court that it's a parking ticket? Well, it says parking ticket on it. Okay, well, so what? Anybody can say parking ticket. Have you called a witness who wrote the parking ticket? Have you called a custodian of records who says this is how parking tickets are actually written? This is how they're kept. They're put on this type of piece of paper. It's got this number. I ran that number. I'm a person who deals with these numbers. And I can tell you that this is a parking ticket that was written on such a day to Jim McIntyre, who was parking illegally in front of the Hi-Fi store. All of those things are foundational requirements to admit that piece of evidence, but they don't have to do with the relevance of it. That could be another objection. After you've established its foundational hurdle, you then have to prove that it is relevant. Well, this parking ticket is relevant because we believe that the defendant got a parking ticket before they went to enter the store to commit the crimes. Gotcha. Okay. Now it's relevant. Is it probative? Let's weigh the probative versus prejudicial value of it. Nobody's going to convict somebody of murder just because they got a parking ticket. Very low prejudice, very high probative value because it proves that the person was at this time at this location where we believe that the crime was committed. But all of that goes back to foundationally, can you establish that the thing you're trying to introduce is in fact that thing? Again, like I said, it usually has to do with documents by showing that you can show that this document is what you purport it to be rather than just saying that. And you can do that through witnesses, through custodians of record, through business records, all of these types of things. So that's what foundation means. You'll see it come up as an objection when they just feel like they haven't established that the thing that they're trying to prove or the document they're trying to enter, they haven't established the basic hurdle of establishing it is what it is. Thank you so much, Joy from Ottawa, Canada, for asking the question. I always love these little nitty-gritty things because I take them for granted that everybody knows what we're talking about, but not necessarily. All right, let's keep it rolling here.
Hi, Josh. This is Maureen from Monterey, and I have a question, which is a good thing because I'm on the line where I'm supposed to be asking a question. I was watching the Donna Adelson trial today, and there was that point where Judge Everett got really upset with the defense for having objections to things that had been brought up in pretrial motions and that he had already decided. He'd already ruled upon those questions, and he was really getting more and more angry with the defense over it, and he threatened to send the jury home, and he wanted to know, why they were bringing it up now when it had already been decided. And I was thinking, man, the defense should have thought about this before they brought this up, because this is really stupid to irritate the judge. But later I started thinking, is this strategy on the part of the defense? Are they doing this on purpose? And does it really matter if they irritate the judge? Do they care? Do they just want to get that message out? And I'm just curious what your take on it might be. Thanks a lot, Josh. Bye-bye.
Maureen from Monterey. Always good to hear from you. Thank you so much, Maureen, for calling. Putting Monterey back on the map there. There we go. Great question. What was up? And this is, as I said, somebody kind of went into this earlier. What was up with the judge? And he's getting after that. What is she wearing the headphones for, by the way? What exactly is this all part of the I can't see, I can't hear hand me my cane and my knitting needles nonsense. Anyhow, Maureen from Monterey wants to know what was up with the judge getting mad at the defense. What are they doing to upset him? There he is in his no shenanigans zone. What were the shenanigans? Well, they started to object to the admissions of certain judges. Hate this, by the way. It's one thing to object to questions as they're happening on the fly. It's another thing to object to answers that are being given that are non-responsive to the question or something. But when the prosecution is admitting pieces of evidence that you've all litigated and you've all talked about and you've been aware of and you've had in your hands for months and months and months, and now you're objecting to it at the moment it's being introduced, this drives judges crazy because they say, we've talked about this. And if we haven't talked about this, why haven't we talked about this? You've known they've had these documents. You've known that they were going to do this. Why are you now waiting while I've got a jury sitting here to start making these objections? So he sends the jury out of the room to have this argument. They have their little argument, and the judge says exactly what I just said. I thought we had this all handled. And then he says, quote, before we leave here today, if we need to go through every single state exhibit and deal with any objections regarding them, we will do so however long that takes, but we are not going to be wasting the jurors' time. Judges have an inordinate sensitivity to wasting jurors' times. The only time I ever get yelled at by a judge is if they feel like they've got a jury waiting and we're making them wait. They can't stand that. And I get it. They've got people here who don't want to be here and they want to respect their time. And I appreciate that. The answer here, though, is it is a little shady on the part of the defense that they're making these objections now when they knew these documents were going to be coming in. They should have made all these objections. They're saying we did judge. Really, what's happening here is this kind of 3D chess where they're trying to irritate the judge? No. I think more than anything, they're trying to make sure they establish a record, and they're trying to make sure that their vociferous objections have been accurately reflected on the record. And they're, listen, I've been in the spot of a defense attorney, and sometimes you don't care who's yelling at you. You got to make these objections and you got to put them on the record. But I am sure that they took that warning from Judge Everett to heart, and they certainly don't want to irritate the man beyond that. I don't want to see that face I don't want to see that eyebrow get any higher if I'm the defense. All right, guys, here we go. This is it. Last question, but it's a treat because it's actually more than one, and you'll see what I mean.
Hey, Josh, it's JC Broadway from Salt Lake City. This is the 4th time I've tried to leave this message. I keep getting cut off, so I have to hurry. Here is a bar exam question. I hope you're in the mood. Okay. A federal grand jury is investigating a wide-ranging conspiracy theory involving several high-ranking executives at a major corporation. The grand jury subpoenas Bob, an employee, to testify about his knowledge of the scheme. During the grand jury proceeding, Bob invokes his Fifth Amendment privilege against self-incrimination. In response, the prosecutor obtains a court order compelling Bob's testimony. The court grants Bob use and derivative use immunity, explicitly stating that his compelled testimony and any evidence derived from it cannot be used against him in a subsequent criminal prosecution. During his testimony, Bob provides details about the conspiracy. During his testimony, Bob states, I know the CEO, John, also kept a separate ledger to track these deals. The prosecution did not previously have knowledge of this separate ledger. Based on this information, the prosecution issues a subpoena to the CEO, John, to produce his personal financial records. John produces the requested documents, and the prosecution finds the separate ledger. The prosecution subsequently brings criminal charges against Bob for a different crime. Got cut off still, even though I was hurrying. I'll just pick up where I left off. The prosecution subsequently brings criminal charges against Bob for a different crime, a past unrelated wire fraud, and intends to use the separate ledger as evidence in that trial. Bob's attorney files a motion to suppress his separate ledger, arguing it is barred by his grant of use and derivative use immunity. The question is, which of the following statements is the most accurate assessment of the admissibility of the separate ledger in Bob's wire fraud trial? I'm going to have to leave the options in a separate message or I'll get cut off. Sorry.
All right. This is great. I'm going to play the rest of it. Don't worry. But just so we're all on board here, this is why I like this one, because it's exactly what we were talking about. Use and derivative use immunity and Wendi Adelson and what's going on and what is derivative use and what is derived from evidence. So Bob enters into a derivative use agreement with the government. The government has him testify. He testifies and he says, John had a separate ledger. That ledger is going to give you everything you know. They go, we never heard about this ledger. They go out and subpoena or get a warrant to John. They get his ledger. They find a bunch of stuff, including some stuff against Bob. And now they want to use it against Bob. And Bob is saying, hey, what happened to my immunity? And the government is saying, poo-poo on your immunity. And here's the question from JC Broadway for the rest of it. All right.
Here are your options. A, the separate ledger is inadmissible because it was discovered as a direct result of Bob's compelled testimony and thus falls under the protection of his use and derivative use immunity. B, the separate ledger is admissible only if the prosecution can demonstrate that the document was obtained from a source wholly independent of Bob's compelled testimony. C, the separate ledger is admissible because use and derivative use immunity does not apply to evidence of separate, unrelated criminal offenses. D, the separate ledger is inadmissible because Bob should have been granted transactional immunity, which is total immunity, which would have fully shielded him from prosecution for any offense related to his testimony. E, the separate ledger is admissible because it is the fruit of an independent investigation against a third party, the CEO, making the connection to Bob's testimony too attenuated. I will leave the answer in the next message.
All right. Here we go. Let's see your answers. Grubba says C. Ohio Palm Mom says A. Tracy from Florida says C. What this will show, if anything, B or C says Helen Scottish Llama. What this will show, if anything, is if I explained it good earlier. I will tell you this too. I could call up my attorney friends right now, and I bet you they wouldn't get the answer to this one right. Oh, Tough B says, Simi Sharp says A or B. All right. I see a lot of C's, a lot of people kind of trying to hedge their bets. Interesting. All right, let's get into the answer, and then you guys can see why that's true. If I can find the answer. Here we go. Come on.
And finally, the answer is B. This option accurately states the governing principle established in Castigar versus United States. To use evidence discovered after a grant of use and derivative use immunity, the prosecution must demonstrate that the evidence comes from a wholly independent source, not tainted by the compelled testimony. The prosecution must prove the independence of the evidence. But we all know that because Josh has taught us that. So thank you very much. Hope you all had fun. And Josh, you know what to do. Call me back.
Call you back. I know what to do. Call you back. Dr. Problatter got it right. B. Why? Why is it B? Why not C? Why not A? Again, this is not the easiest concept in the entire world to understand, but here's what it comes down. This is a great example of derivative use. So you've got Bob. Bob is testifying. Words are coming out of Bob's mouth. They can't use those words against Bob. We know that. But then Bob tells them about something else. Bob tells them about this ledger. So now they go find the ledger, and the ledger was derived from Bob's testimony, right? So you've got the use and the derivative use. They can't use that. And you say, well, then that's what I said. I said they can't use it because it's derivative use. But it's only derivative use if they prove that they could not have got it some other independent way. So just because Bob talks about the ledger doesn't mean he somehow insulates himself from that ledger ever being used. If Bob mentioned a witness, doesn't mean they can ever use that witness against Bob. It just means if they cannot have ever arrived at that without Bob, they can't use it against Bob. But B says very carefully, if there is independent way that they get to that ledger, then they can use it against Bob. Now, you say, well, how did they do that? Well, let's say John was already a person they were going to interview. John was on their witness list. John was someone that they had set up an interview with, and John was bringing his ledger. You can't say that the government is forever prevented from using that ledger because Bob happened to mention it. But if they never heard of John, never heard of his ledger, never even knew about it, then yeah, Bob can say, you got that from me. You got that from me, and you derived new testimony from it. So you can't use it. That's why B is the answer. Did that make sense? Did that clear up anything? Are we still all thoroughly confused? But the question didn't show how they arrived at it independently. You are correct, Tiff Knox. But the answer says they cannot use it unless they arrive at it independently. So no, they cannot arrive. They did not say how they arrived at it independently, but the answer didn't say yes because they arrived at it independently. And what you're finding out here, Tiff Knox, is just exactly how tricky they try to get with you on the bar. The very specific answer in B is the most correct, even though it is true they haven't shown any independent source, but they could, and that's why B is correct. But how do you prove they could get it? Like I said, they would have to show some other independent source of that information. John was already on their witness list. John had sent them a copy of it and they just hadn't opened their mail yet. Whatever it is, they're going to have to show it, and they're going to have to litigate it too. You can be sure Bob's going to want to litigate that. But if they had never had John on there as a person in their notes, they never knew John had this ledger other than Bob saying so, then Bob's got a really good case there. All right. I'm comfortably confused and I like it. And that's exactly where we like to keep you. That's the sweet spot here at Courtroom Confidential. He's comfortably confused. All right. Well, I'm sure we'll get a bunch of more questions on use immunity next week. So we'll try to clear it up a little bit more. But that is all the questions we've got for you this week. By the way, Sunday Fun Day, the great thing about it is because the questions don't really go old a lot of the time. We're talking about older cases and concepts. We've got a whole playlist of old Sunday Fun Days. If you guys want to go back and check them out, we do. Tiffany painstakingly goes through and marks all of the chapters. So if you want to go back and just kind of look through some of these old Sunday Fun Days, we encourage you to do that. Also, check out the website, thecourtroomconfidential.com. If you are saying to yourself, this is fun, I want to get in the sandbox too, how can I leave a message? You go to thecourtroomconfidential.com and click on leave us a message, that tab there to the right, and you can leave us a message. Ask about true crime, ask about legal concepts, whatever you got going through your head. Then if you're looking for how do I become a member, because this is fun and I also want to become a member and become part of the CC crew, click on become a member and you can find out about all the benefits of that, including we have monthly members only live streams. And you can find out about the merch that we have if you click on the shop, and we've got some brand new stuff that we wanted to share with you guys today. So first of all, we've got new colors of shirts, a lot of new fun stuff, including a brand new blue color called CC Crew Blue, newly named by one of our members. We've got new tumblers. We've got this wine tumbler, says CC Crew. On the back, it says, "Let's get juiced for when you want your Pinot on the go." We've got this big coffee / iced coffee, do whatever you want with it tumbler. I guess you could put wine in that too if you're having a, especially if you're still trying to figure out derivative use immunity, fill this up with wine. It gets all that much easier. Again, it's got the CC Crew logo and it says, "Let's get juiced" on the back. And we got new shirts, including this one. And you're like, why is that a new shirt? I've seen that all over the place. Well, you haven't seen the back. And it says, "What's happening here?" So you can walk around your neighborhood and everyone can think you are thoroughly confused. Brand new Courtroom Confidential t-shirts with "What's happening here" on the back. You guys had been requesting it and we said it's time. So check those out as well. Also, something that we're very proud to share with you, we are always looking for ways to continue to provide you guys with advertisement-free live streams. We never want YouTube interrupting these to show you an ad, and so we're able to secure a sponsor for the channel, and that is Aura. If you are interested in or concerned at all about your internet security, your identity being out there on the web, then Aura is for you. It is your one-stop, all-in-one digital security platform. If you're dealing with robocalls or spam emails or personal data leaks or password leaks, this is for you. You go to aura.com/courtroomconfidential, and we are able to give you a free 14-day trial. But you have to type it in that way or go on this, scan that little QR code, aura.com/courtroomconfidential. You get 14 days to try it, and they give you alerts. They give you a VPN. They give you an antivirus. They give you a password manager. They give you ID theft insurance, US-based support. And I love it. We've been using it, and I still continue to get emails from companies saying, "We've removed your information," from Aura saying, "Here's your latest security kind of update." The robocalls are slowly getting less and less every single day. So please check it out. It's a free for 14-day product. It's a great product. We really like it. We wouldn't recommend it to you if we didn't believe in it. And it's also a great way to support the channel. So please check it out. What did you miss on Saturday? We had the weekly roundup. We talked about Donna Adelson. We talked about Bryan Kohberger. We talked about the Menendez brothers. We didn't even get into that today. Both of them were denied bail on Thursday and Friday. So if you want to hear all of the latest on what took place this week, check it out. Courtney Clenny was also in court. Check out the weekly roundup, which is already up on the channel. Then all this week, stay tuned to our sister channel, Courtroom Confidential Live Trials. Go there right now and subscribe and set the notification so you don't miss one day of live trial. Tomorrow, we're thinking Wendi might testify. So come watch it with us, be in the chat with all your CC Crew fellow members. And I think you guys are going to enjoy chatting with everybody. Monday, that evening, tomorrow evening, 5 p.m. Pacific, 8 p.m. Eastern, we are having Gigi from Pretty Lies and Alibis come on to talk to us about the Donna Adelson case. She's been following this one very closely. And again, we think Wendi will testify tomorrow, so we'll have a lot to chat about. So join us tomorrow night, 5 p.m. Pacific, 8 p.m. Eastern, live. I'll be talking with Gigi. She's always fun, from Pretty Lies and Alibis. And then Wednesday, we have a little guest that some of you guys may have heard of, and that is Gisela from Grizzly True Crime. Are you still here, G? You still jogging? You still yogging? Check out our chat with Gisela live at 5 p.m. Pacific, 8 p.m. Eastern on Wednesday. And I think, again, we're going to be talking about Donna because she's following that case very closely. And I'm curious to hear her thoughts because she's, high on the snark factor. And I'm really curious to hear her reaction to the first few days of trial. Finally, just a couple of weeks. God, August 24th. Do you believe August flew by already? Well, in just a couple of weeks, September 5th through 7th, we are going to CrimeCon in Denver. We've got a booth. We just got our stuff for the booth. We're bringing out a bunch of fun giveaways. We would love for you to come by and say hi. If you still haven't purchased a ticket and you're thinking about it, enter the discount code courtroom, all caps, all one word, at checkout. You get 10% off. And we hope that you join us because we got nominated. We're very, very proud to have been nominated in the podcast Outstanding Episodic Series category at our first ever CrimeCon. And you might be there for a win, or I don't know. We'll see. We're just happy to be nominated. It's a great group of people that we're nominated with. So come check that out at CrimeCon and we'll let you know all about it. Plus, when we're at CrimeCon, I'm going to be doing a lot of these members only live streams from my phone. I told Tiffany I would do as many as I could. I refuse to bring a selfie stick, and I don't want to look like some millennial jerk walking around talking into my phone all the time, but I will do a lot of live streams, and you'll get to see Kaylin and Tiffany there with me and whoever else we run into, and maybe even the baby will make a little appearance on that. So join us virtually if you can't make it in person to CrimeCon. All right, everybody. Thank you so much. Thank you to our mods, Shy Gal, Sonia, Afton, Kathy, and therapists. Thank you for keeping everybody in line here as we play in the sandbox. And thank you so much to Kaylin for not yelling at me too much. She'll yell at me, but she won't give me a hard time. It'll be like very mild yelling later today. And to Tiffany for being the best thing that ever happened to me. Thank you guys so much. Have a great rest of your Sunday. Take care.